Yes, but it's a strongly qualified yes. What you'll hear today is that there is no clear law currently which prohibits employers, including employers in the healthcare industry, from mandating vaccinations for COVID-19, but there are a bunch of legal considerations and, frankly, risks that need to be taken into account if employers want to go down that path. And I suspect that after we talk today, many of you, as I imagine, are in the same positions as many of my own clients who I've been advising on this issue, may ultimately determine that the risks are so significant that your best course of action would be to not mandate vaccines, but rather to strongly encourage them. As I say, that's not required right now by law, but I think all of these areas that we're going to talk about entail significant risks to employers if you were to mandate vaccinations. So let me start by just giving a little bit of background to everybody. Outside of the healthcare field, mandated vaccinations have actually been fairly rare throughout U.S. history. Within the healthcare field, there have been a number of employers that have, in fact, mandated vaccinations for certain diseases, for influenza and so on. There have also been states that have required certain healthcare providers to mandate those vaccinations. It's clear under Supreme Court law, and it's old law, we're talking about law from the early 20th century, that states do in fact have the power to either mandate vaccinations for certain employers or conversely to say that certain vaccinations can't be mandated. We haven't seen that yet by any states, but certainly vaccinations are a highly politicized issue in today's environment. We have a lot of legislatures that will be coming back together after or in the new year. And we could very well start seeing some laws from legislatures that either mandate vaccinations or conversely say that employers will not be permitted to mandate vaccinations. So keep tabs on that in the coming months. For a little bit more background, which will become relevant to some of the things we're talking about today, the vaccinations that are available now are those through Pfizer and Moderna. I'm sure everyone on this call knows that those have been approved by the FDA under what's called emergency use authorization, which is authorization that's granted after a review process, which is somewhat less rigorous than the process that would be required for full FDA licensure. And the relevance to that is that in light of kind of the expedited procedure under which these vaccines have been approved, if employers were to mandate them for their employees, and if employees were to have adverse reactions, that would make those employees much more likely to be able to successfully sue under some of the legal theories that we've been talking about today, or that we will talk about today. So let me give you an overview of exactly what we'll talk about. As you can see on this slide, the main considerations if you want to mandate vaccines for your employees relate to medical issues under the Americans with Disabilities Act. We'll talk about that. Generally, if someone has a disability that prevents them from taking the vaccine, you have to accommodate it. A similar obligation that exists under Title VII of the Civil Rights Act relating to religious beliefs. If someone has a sincerely held religious belief that prevents him or her from taking the vaccine, again, employers generally have to accommodate that. Other concerns relate to liability. So let's say you do, in fact, mandate some of these vaccinations. Let's say people develop adverse reactions. That could potentially cause you some exposure under workers' compensation laws or other state laws, which we're going to talk about. Some laws that have to do, for example, with lawful off-duty activities. If employees do something outside of the work that they protest the vaccinations or claim that vaccinations are unsafe under these lawful off-duty activities statutes. If you were to force them to take a vaccination, you could be opening yourself up to some exposure. We'll also talk about labor law implications. These are rules imposed by the National Labor Relations Act. Again, if people, especially in the politicized environment that we have today, if people were to band together and claim that they think vaccinations are unsafe, that type of activity could be protected by the NLRA. And then we'll talk about some practical considerations if you want to mandate vaccinations that also could potentially militate against that determination. It makes sense in theory to say we're going to mandate vaccinations, but actually trying to come up with policies that enforce that discipline people who, if they don't take vaccinations, are lawful policies in that they discipline people in a non-discriminatory way. Those are all other concerns that you have to take into account if you want to mandate vaccinations. So let me start with the religious belief exemption. As I mentioned, Title VII of the Civil Rights Act prohibits religious discrimination by employers. And it also requires that employers accommodate employees' sincerely held religious beliefs. Now, this can be relevant in relation to mandated vaccinations if employees claim that they can't take the vaccine because they have some sort of religious belief that prohibits them from taking it. If that occurs, then employers are required to accommodate that belief, at least absent undue hardship to the employer. And accommodation would mean presumably exempting the employee from the requirement to take the vaccine. Now, as I said, you have to accommodate absent undue hardship. Undue hardship is defined fairly minimally in the Title VII context with relation to religious accommodations. An undue hardship would be anything other than a de minimis cost to the employer. So that does provide some support for you there, although generally you are going to have to accommodate religious objections to the vaccine. The EEOC has put out some guidance which says that if generally if somebody objects to the vaccine based on a purported religious belief, that employers are generally supposed to sort of accept that objection at face value, not probe too much. The exception is if the employer has an objective basis to think that the religious belief may not be sincere, in which case the employer can, in fact, ask for some follow-up documentation or additional information supporting that belief. But that's a fairly narrow exception. I'll also note that courts have been pretty lenient in what they consider to be a sincerely held religious belief. It's the court's belief that it's not incumbent upon the court to sort of probe down into people's religious convictions, figure out if they're sincere or not. And so as a result of that, courts will often extend deference to express religious beliefs, even if they're unorthodox. So, it's clear that you don't have to be part of a certain organized religion that opposes vaccines based on some sort of tenet of that religion. It can be, personal religious beliefs as well. So if you have an employee who raises this issue, be very careful. I will say that courts have held, however, that a religious belief has to be exactly that. It has to be religious. So secular beliefs wouldn't qualify. For example, if you have someone who is anti-vaxxer, doesn't believe in vaccines on principle and or thinks they're unsafe, unless there's a religious component to that, that generally isn't going to be protected. The second big area that you need to take into account in relation to potentially mandating vaccines is the ADA, the Americans with Disabilities Act. The ADA prohibits discrimination on the basis of disabilities, and also like Title VII, it requires accommodations for people who are disabled. And so in the context of potentially mandating vaccines, if an employer wanted to mandate a vaccine for all employees, and employees say, well, wait a second, I've got a disability under the ADA that prevents me from taking the vaccine, or perhaps if a medical provider for that employee says, in light of the fact that these vaccines are only approved under emergency use authorization and maybe the full implications of how they work or won't work, or to the extent to which they will work, or interactions with other underlying conditions or medications remains unknown. If for whatever those medical reasons are, somebody claims they can't take the vaccine, again, you'll generally have to accommodate that if in fact they have a disability that prevents them from taking it. Again, like under Title VII, there's an exception if exempting the person from the vaccine would cause undue hardship on the employer. And undue hardship in this context is defined as significant difficulty or expense. If somebody does object and you determine they are disabled, they've shown that they can't take the vaccine, then you have to accommodate them. And sort of in the Title VII context, in the religious discrimination context we just talked about, you would have to accommodate them presumably by exempting them from the requirement to take the vaccine. You might also need to take other steps if a non-vaccinated employee would pose a risk to other people at the work site. You might need to take steps like permitting that person to telecommute for a while, maybe a leave of absence, maybe moving them away from other employees, from patients, and so on. But you will generally have to accommodate that issue. I'll note that there's a similar obligation under what's called the Pregnancy Discrimination Act, which, as it sounds, prohibits discrimination on the basis of pregnancy, but also requires accommodation of any temporary disabilities that may be related to pregnancy. So if somebody has such a disability and their healthcare provider says, they can't take the vaccine for that reason, again, you'll generally have to accommodate that. Another point with respect to vaccines under the ADA is that it's clear that even if you decide to mandate vaccines, you certainly can't mandate it as part of the application process. You can't say, people will have to be vaccinated to apply with you. What you can do is, after a conditional job offer is extended to employees, you could then potentially impose the mandatory vaccine requirement. But even then, you'd have to make sure that you're doing it, imposing that requirement with respect to all employees who are entering into the same job position. One other thing that the ADA requires is it has strict rules relating to disability-related inquiries. If you're asking questions or making inquiries that can implicate disability issues, those inquiries have to be job-related and consistent with business necessity. And I mentioned that by way of segueing into the next section, which Alex is going to take over now. The EEOC issued some guidance in the middle of December, which elaborated upon all these issues, especially the issues under the ADA. So, Alex, go ahead.
Thanks, Brad. So as Brad sort of previewed for everyone, pre-December, obviously this issue was a hot topic, heating up certainly as it became obvious that some of the vaccines were heading to at least EUA approval, and there were a number of legal blogs and scholars, healthcare professionals who were anticipating that the answer to the question, can we have these mandatory vaccinations, what can employers do, would be yes, with the restrictions that Brad, anticipating the restrictions that Brad has just covered at a high level. So the EEOC issued, it has technical assistance publication, which is in a kind of helpful Q&A format for employers, where they have now included a section K, on vaccinations. So essentially the EEOC has said that all employers can require mandatory vaccines as long as the employer allows employees to receive the vaccine from a third party that does not have a contract with the employer, or they can establish that the vaccine requirements are job-related and consistent with business necessity, which we'll get into later, and they need to follow the accommodation requirements under the Americans with Disabilities Act and Title VII that Brad covered a little previously. So the main restriction on requiring employees to be vaccinated it really comes from the ADA, which has those strict restrictions on an employer's ability to require employees to undergo a medical examination or make disability-related inquiries. So the EEOC stated in its guidance definitively that the vaccine is not a medical examination and that asking employees about whether or not they have been vaccinated is not a disability-related inquiry. And I'm sorry, I'm now just advancing my slides. So the larger issue is going to come up with pre-screening questions. So the EEOC has anticipated that if there are pre-screening questions asked by the employer or a contractor administering the vaccine at the employer's request, that instead could implicate the ADA's provision on disability-related inquiries, as that is likely to elicit information about a disability. So if the employer decides to administer the vaccine, which can be of a particular concern in the healthcare industry, or a contractor does on its behalf, the employer has to show that such pre-screening questions are job-related and consistent with business necessity. So to meet that standard, what an employer has to do is demonstrate that an employee who refuses to answer pre-screening questions and therefore cannot receive the vaccine will pose a direct threat to the health and safety of him, herself, or others. However, there are some exceptions. So the two circumstances in which these screening questions can be asked without needing to satisfy that job-related and consistent with business necessity requirement is going to be, first, if there's a voluntary program. So if the employer offers vaccination on a voluntary basis and the decision to answer the pre-screening questions is also voluntary. So that should avoid, at least in the EEOC's estimation, any issues under the ADA. Then the other situation would be if there is a vaccine provided by a third party. So if the employer mandates that employees receive a COVID vaccine and an employee receives the vaccine from that third party with whom the employer, again, does not have a contract, the ADA restriction on disability-related inquiries should not be implicated. So with this last point in mind, it should be permissible for all employers under the ADA to mandate the COVID vaccine subject to accommodation requests that Brad discussed and will then continue to discuss later, as long as the employees receive the vaccine from that third-party pharmacy or other medical provider. Again, would be employer does not have a contract. So what can employers do as far as requiring proof of vaccination and what pitfalls may that implicate? So the EEOC has said that you can require workers to prove that they have received the COVID-19 vaccine. But in that, what an employer should be looking for, an HR department, whoever is administering an employee's vaccination program, is a simple proof of receipt of the vaccination, because that is not likely to elicit information about a disability. So that would avoid the prohibition on disability-related inquiries from an employer. But asking subsequent questions, and this is something we've seen some interest in from employers about why, could get into that area about needing to relate to the ADA standard about disability-related inquiries, that they need to be job-related and consistent with business necessity. So as far as employees opting out goes, with respect to mandating vaccines, the EEOC guidance, again, that was issued in mid-December, states that the ADA allows an employer to have a qualification standard that includes a requirement that an individual shall not pose a direct threat to the health or safety of individuals in the workplace. However, if a safety-based qualification, such as the vaccination requirement, screens out or tends to screen out an individual with a disability, the employer must show that an unvaccinated employee would pose a direct threat due to that significant risk of substantial harm. The EEOC has gone on to explain that a determination that an individual presents a direct threat would necessarily include a determination that an unvaccinated individual will expose others to the virus at the work site. Again, this is a kind of unique situation in light of the global pandemic we find ourselves in. So even if that determination about a direct threat is made, the EEOC has cautioned that the employee cannot be automatically excluded from the workplace or subject to any other action unless there is no way to provide a reasonable accommodation, again, absent undue hardship, that would eliminate or reduce that risk posed by the unvaccinated employee. So exclusion from the workplace, again, is not the same as termination, and employees may be entitled to telework or take leave provided by law or under the employer's policies, many of the same considerations that employers are currently going through when faced with an employee that's currently infected with COVID or quarantining based on exposure to COVID. So in addition, employers, again, must still engage in that interactive process regarding disability-related requests for accommodation. And the EEOC has stated that in determining whether there is undue hardship, the employer should consider the number of employees who've already been vaccinated in the workplace and the amount of contact the employee will have with others whose vaccination status is unknown. The EEOC has said that employers may also want to consider the CDC recommendations concerning what might be an effective accommodation, and also OSHA standards and guidance concerning particular job duties at workplaces.
Thanks, Alex. Luke, if you could give me control of the PowerPoint again, please. So, to sort of summarize what Alex was talking about, I think she did a good job. I know it can be hard to understand this on first pass, and part of the difficulty is because the EEOC's guidance, frankly, wasn't that helpful and was somewhat confused in and of itself. I'll note that at the end of this presentation, we will point you towards a blog that we have at Holland and Hart where we've written articles both on mandatory vaccinations generally and on the EEOC's new guidance, which you can read at your leisure and maybe help digest some of this better. I think I can summarize basically what the EEOC provided in that new guidance as follows. One, it confirmed that you certainly have to accommodate people if they have a disability that would prohibit them from taking the vaccine. If you can't accommodate them, it made perfectly clear that you can't just fire them. You have to take other steps like, potentially extending them leave or letting them work from home, or, taking other steps to protect your customers or patients or vaccinated employees against the non-vaccinated employee. And then it kind of got into all that inside baseball that Alex was talking about if you're asking pre-screening questions for a vaccine, whether those constitute disability-related inquiries, which they do, and what that means. And it means it has to be consistent with job necessity, or consistent with the job and business necessity. As a practical matter, I think the takeaway from this guidance is one, if you make your vaccination program voluntary, you can kind of avoid all these issues. But two, even if you elect not to make it voluntary, you can avoid a lot of these issues if you aren't involved in providing the vaccine. If you don't administer it yourself, and if you don't contract with another party to administer it, if you just simply tell your employees, hey, you'll get vaccinated, and they go do it somewhere else, then you are not, as the employer, implicated in all these issues about the pre-screening questions, and you'll generally be safe. So I think those are the takeaways, and there'll be more detail in the article if you want to look at it, which we'll point you to at the end of this presentation. Let me jump now into the labor law protections that I previewed at the outset. We've been talking about the ADA implications of mandatory vaccines and the religious accommodation implications of it. But one area that a lot of employers maybe don't have on their radar is the labor law implications. And labor law is a term of art meaning union law. It's controlled by the National Labor Relations Act. The reason why I think this may not be on a lot of employers' radar is because not all employers are unionized, and those that aren't unionized say, we don't have to worry about this. But they're wrong. The reason why is the NLRA creates rights that apply both to unionized workforces and non-unionized workforces. And one of those rights is created by Section 7 of the Act, which protects the ability of workers to band together and engage in what's called protected concerted activity. And one type of that activity can be protesting allegedly unsafe work rules. And so what we could very well encounter is if you mandate vaccines, and whether or not you are a unionized employer, if employees get together and try and push back against that, and push back based on the claim that they think the vaccines are unsafe, that could very well constitute protected concerted activity, meaning that if you were to take some disciplinary action against them, terminate them, for example, that could violate the NLRA, expose you to unfair labor practice charges, and a whole panoply of potential remedies under the NLRA. For the employers who are unionized, you're still subject to those Section 7 responsibilities and rights as I was talking about, but you would also have to bargain with your union about mandatory vaccines. It's fairly clear that mandatory vaccinations would be a mandatory subject of bargaining under the NLRA, meaning that you couldn't unilaterally impose a rule that everybody gets vaccinated. One exception may be if you have a CBA, a collective bargaining agreement that has a strong management's rights clause, which reserves to the employer the right to impose certain work rules. And if your CBA has a strong, zipper clause saying we don't have to bargain about anything that isn't treated in the CBA, in that situation, maybe you'd be able to unilaterally implement a mandatory vaccination program. But even then, the NLRA requires what's called effects bargaining, bargaining over the effects of some rule, even if the employer has a right to implement it. So if you're unionized, think carefully about whether you can do this on your own. Even if you determine that you can, perhaps under your CBA, you're still probably going to have to engage in effects bargaining with the union, talking about exactly how this program will be implemented. Let's talk a little bit now about potential employer liability. So let's say you decide that you do want to mandate vaccines. Let's say you do so, and then somebody has an adverse reaction to the vaccine. In that situation, you could very well be facing a workers' compensation claim. Workers' comp is controlled by, at the state level, each state's workers' comp laws vary and vary significantly from one another. But generally, what workers' comp provides is that if somebody is injured at the workplace, say through negligence, rather than letting that person sue through a common law tort claim, say a traditional negligence claim, they have to go through the workers' compensation system. And so, if somebody, especially if you have a mandated vaccine requirement, and maybe if the vaccine is administered on your property, but maybe even if not, if somebody develops an adverse reaction, you could very well be facing a workers' comp claim. The idea behind workers' comp is to sort of create a administrative system that displaces the traditional court system with respect to certain tort claims. Tort claims are personal injury claims. And so usually, in most cases, if you ran into that situation, you'd probably be facing a workers' comp claim, not a tort claim, although we're in a new frontier on all these things. None of them have been litigated yet. And so it's possible that you could face tort claims as well. I think that'd be unlikely, but possible, perhaps under some sort of intentional tort theory. There are exceptions to the workers' compensation exclusive remedy for certain torts that are intentional or that are caused willfully or with knowledge that they may hurt somebody. I will mention what's called the PrEP Act, the Public Readiness and Emergency Preparedness Act. This is a federal act which, again, it's unclear exactly how it will apply, but could provide you some defense, say in one of these workers' comp claims or to a tort claim. What it does is it creates some type of limited immunity for employers who administer the vaccines. But it's the immunity now is controlled in large part by administrative decisions, not by the statute itself. We don't know with the new administration coming in whether that will remain. The issue of creating liability exemptions for employers in relation to the vaccine and in relation to claims that people got sick from COVID at the workplace generally, that's a kind of a hot button political topic right now, is one of the issues that threatened to hold up the appropriations bill at the end of December. We could see from the new Congress some movement on this, although it's something that the Republicans were pushing more than the Democrats, so it's unlikely. But it could also happen at the state level in some respects. So keep an eye out for potential laws that either or that could potentially limit your liability. Let me say this, though. Even if the PrEP Act applies to you or maybe some other immunity limiting law, those will generally address those personal injury claims, those tort claims. But there are all sorts of other state law claims that you could very well face if you require people to take vaccines. And let me just run through a few of them. I previewed at the outset that a lot of states have something called an unlawful off-duty activities statute. Many years ago, this was called a smoker's right statute, at least here in Colorado, because the original idea was it's legal to smoke if you're, and we're just talking about tobacco now. This is before recreational marijuana in Colorado, but it's legal to smoke. If you smoke off-duty, your employer shouldn't be able to do anything about it. That rationale has now been vastly expanded to all sorts of lawful off-duty activities. And so states that have statutes like this, what they generally say is, if you're engaged in some sort of lawful duty outside of work, your employer can't terminate you for it. And so here, sort of like what we were talking about in relation to the NLRA, if people band together under the NLRA and protest or push back against vaccines, they could be protected under that act. Under this unlawful off-duty activities statute, they wouldn't even need to band together. If someone off-duty is outspoken against vaccines and you, the employer, know about it, and if you terminate them for not taking the vaccine, especially if you do so shortly after somehow being aware of this public off-duty activity, you could be setting yourself up for one of these claims. Another kind of state law concern is something called a public policy discharge claim. And so most states in the United States say that you can terminate someone for any reason or no reason, as long as it's not an illegal reason. That's called the at-will employment doctrine. But it's that exception, not firing someone for an illegal reason, that really swallows the rule. And one of those exceptions is something called a public policy discharge claim. And it's a vague claim, but generally how it plays out is if an employee can point to some sort of public policy, meaning some kind of policy expressed in law that the state is trying to uphold as reflected in the law, and if they, meaning the employee, takes some action in furtherance of that policy and then is terminated, they can essentially say it was retaliation for exercising some right or retaliation for trying to exercise some right that's enshrined in public policy. Now, how this could come up here is still a little unclear, but there are at least a couple theories that are working their ways through the plaintiff's bar. And one of them goes back to what we were initially talking about, which is that the vaccines have been issued under the emergency use authorization of the FDA. And in granting that authorization, one of the things that the FDA did is it said that when these vaccines are given, they have to be given with a fact sheet. And one of the things that the fact sheet has to tell recipients of the vaccines is that they are receiving them voluntarily. They can choose not to receive them. So the theory here would seem to be in the plaintiff's bar that if you have a mandatory vaccine program, someone doesn't take the vaccine and you fire them, that employee could point to this emergency use authorization and the fact sheet required under it and the public policy enshrined in it, namely that you can choose whether or not to take the vaccine and say, hey, I was exercising this right and you terminated me for it. That could turn out to be a viable claim. We just don't know. It hasn't been tested yet. And it'll depend on what state this is brought in. So I'm in Colorado. We certainly have public policy discharge claims here. So you could see people trying to bring that type of claim. I'll mention one other state law issue in Colorado, which is Colorado also enacted in its last legislative session a new COVID whistleblower law. And generally what the law is intended to do is to protect people who raise concerns about actions their employer may be taking to guard against COVID. But, perversely, I think this statute also could potentially be twisted to protect people who don't want to take the vaccine. Because the way the statute is worded, it generally says if, employees raise good faith concerns about measures taken to combat COVID-19, that employers can't take retaliatory action against them. So that could very well potentially apply to a situation where an employee says, hey, you've got this action designed to combat against COVID, namely the vaccine. I think it's unsafe. I'm raising a good faith concern that I think it's unsafe. And then if you were to terminate them for not taking the vaccine, potentially they could try and bring a claim under this new COVID whistleblower law. So a lot of very state-specific laws that you need to take into account, many of which are still, the legal theories behind them are being worked out by plaintiffs' attorneys. But if there are mandatory vaccine programs, we could very well see claims by those attorneys based on any of all these theories, and potentially even on a class basis. Let me talk now about some of the practical considerations if you do in fact want to mandate vaccines. We've been talking about the legal implications of doing so, but if you were to do it, there'd also be a host of practical implications. You'd have to think about such things and probably come up with policies in advance to address such issues as, who's going to pay for the vaccine? Do you force the employer, the employee to pay? Does the employer pay itself? Paid time off. Do you give people time off to get the vaccine or not? Issues like what happens if you get the vaccine and it wears off? Are you going to force people to take a second vaccine? Or, God forbid, if these new variants out there can't be controlled by the vaccine, are you going to require multiple vaccines to guard against them? So, a bunch of practical concerns you'd have to think about in advance. And then also you'd have to make sure that if you mandate these mandate these vaccines, that you're doing so in a way that isn't discriminatory in the way that they're mandated. Or put differently, if you discipline people for not taking the vaccine under your mandatory policy, you have to make sure that you're disciplining them evenly. If you don't, if you give, certain people exceptions, maybe, frankly, more important people at your organization who don't want to do it, but you don't want to, force the issue, but you do force the issue with other people and discipline or terminate them. All those types of disparate activities, disparate treatment of folks could set up discrimination claims if these policies are enforced in an inconsistent way with respect to people who are in different protected groups. And by protected groups, I mean, sex, race, national origin, disability, all the groups that are protected under federal and state law. One other thing, I guess I already kind of mentioned this before, but one of the big takeaways from that new EEOC guidance is if you decide to mandate the vaccines, one of the things that you probably want to do, it's reasonably clear from the guidance, is to play no role in the administration of the vaccine. And that may be counterintuitive for a lot of healthcare clients who have the ability to do it. But if you don't play a role, that'll give you a bunch of protections. You won't be subject to those ADA standards for the pre-screening questions. Someone else will have to deal with that. You won't have to deal with implications under the Genetic Information Non-Discrimination Act. That act generally prohibits employers, except in certain circumstances, from obtaining genetic information, acquiring genetic information from their employees. And again, potentially that could be acquired in pre-screening questions relating to the vaccine. But if you outsource this to somebody else, and when I say outsource, I mean let somebody else do it. You can't even contract with someone else. But if you have someone else do it, then you're going to avoid those GNET questions as well. So I talked a fair amount about potential liability if you give someone the vaccine and if they have an adverse reaction, workers' comp liability, potential liability under other theories. But let's look at the flip side. What if you don't mandate vaccines? Is there any threat to you in not mandating them? And that's a good question. And the argument that there could be is based largely on OSHA's General Duties Clause, which is a clause that requires employers to provide a workplace that's free from recognized hazards that could potentially lead to death or serious physical harm. So the theory here is if you don't mandate vaccines, a whole bunch of people in your workplace get sick, are you violating that General Duties Clause? And I think that's a legitimate concern, but probably the answer is going to be no. And I say probably because there isn't good guidance from OSHA on this point yet. It may be forthcoming, but there is some guidance from OSHA from 2009, which related to similar issues. And that 2009 guidance generally stood for the proposition that, yes, under OSHA's view, you can mandate vaccines. However, when you're doing so, you have to make sure that employees are fully aware of the risks of those vaccines. And if employees raise concerns about those risks based on a medical condition that they have, that those employees may be protected by OSHA's whistleblower protections. So I think the long and short of it is now, we don't anticipate that OSHA would come down on folks for not mandating vaccines, at least based on this older guidance, which seems to suggest that although you can do it, you have to, be careful and let people object if they have a medical condition. Instead, probably you're going to satisfy your requirements with respect to the General Duties Clause when you're taking other steps to protect the workplace. When you're, following your local health orders, requiring masks, requiring social distancing, taking other steps to guard against the coronavirus. And let me conclude with just a few other practical considerations, kind of irrespective of whether or not you do want to mandate vaccines. However you come down on it, it's clear that it'll be helpful for you and really essential to have a good communication plan in place. Especially if you are going to do encouraged vaccines, but not mandatory vaccines, you probably want to take steps to really encourage it. Create an informational campaign at your organization explaining why it's helpful to people, avoiding the sort of political arguments on either side of the divide, which could turn people off. Have your leaders in the organization get vaccinated, and maybe do it publicly. Maybe have people in the local medical community get vaccinated publicly to convey to others that that it's safe and that it's a good thing to do. Another path that you can think about is creating voluntary incentives for people to get vaccinated. We've been talking about making it mandatory and kind of using a stick, the threat of discipline or termination if people don't do it. But maybe you want to flip that around and create incentives for them to do it. That is a good approach. One potential subvariant of that would be doing something under your wellness plans. Wellness plans often incentivize people to take actions to be healthier. You could potentially do this under a wellness plan, but that would have to be very carefully thought out and probably planned out with counsel in advance, because wellness plans, among other things, have to be truly voluntary. They also have to have carve-outs for, all these ADA concerns that we were talking about, people who can't do it for one reason or another. But just generally something to keep in mind. Think about incentives rather than disincentives. And then also, I would urge you to think about unintended consequences of mandating vaccines. And especially in the healthcare field, we know that many healthcare providers are extremely short-staffed, have difficulty keeping up with all the infections right now. If you make vaccines mandatory, that could have unintended consequences, like potentially affecting your staffing going forward. And that could happen if employees quit because they don't want to take the vaccine, if they're fired for not taking the vaccine, if you have to accommodate people for not taking the vaccine, and that accommodation is working from home or working in non-patient-facing capacities and so on. All those types of things could potentially flow from a mandatory vaccine program, so be very practical as well when you're considering whether or not to do this. And I promised at maybe in the middle of our presentation, we have written here at Holland & Hart a couple articles on these issues. I know it's hard to kind of get it all down at first gulp in a webinar like this, but I'd urge you to take a look at these articles for more information. The articles are located on a blog that we have for our labor and employment group called Employers Lawyers blog. You see the link right there. And then the guidance we put out was a very comprehensive article on December 11 that really talked about most of the issues that we talked about today. And then a follow-up article we put out on December 22, which talked about the updated guidance from the EEOC. So I'd urge you to look at that for more information. You can also, if you're interested, sign up to get articles like this as we write them and send them out. If you sign up, you'll just get it in your inbox. So with that, let me conclude and see if we have any questions. We'll just take a few minutes of questions. If you have some, why don't you try and type them into the Q&A link. And I'm trying to look at some that may have already come in so far. The first one says, can accommodations be in the nature of allowing a person to work remotely if they can do their job? And the answer to that is yes, absolutely, it can be. I'd also point out that, the ADA interactive process requires you to engage, to explore all sorts of potential accommodations with an employee. It can certainly be remote work, but it can be all sorts of other things that the parties think of. There isn't anything that does or does not fit into the category of reasonable accommodations. It's whatever the parties can really agree to that will allow someone to do their job. And if you go through all the possibilities, you can't reach, any agreement or decide on any accommodation that works. You also potentially have to give people unpaid leave under the ADA. So keep that in mind. Let me try and look through a couple more questions here. So this next question asks, do I mandate that each employee do pre-screening to a third party? They are required to go for pre-screening, and they can still decline. That's a good question. I think the question is, the advice, one piece of advice we were giving was, if you decide to mandate this, you're probably going to be a lot safer having people go to a third party, not to provide the vaccines yourself. And the question, I think this question is, if they go to that third party and they still don't want to get the vaccine, can they then decline? If that's the question, I think we're really talking about two different issues. I think you would want to use a third party if you're mandating a vaccine because that will give you protection. But if an employee goes to that third party and declines, then you're in this kind of strange place where, under the ADA, you're technically able to make vaccines mandatory if you give people an accommodation. But on the other hand, the emergency use authorization fact sheet says people can decline. I think the long and short of it is you'd be at significant risk if you tried to terminate someone if they went to that third party and declined to take the vaccine, even if you had a purportedly mandatory program. A couple other questions about the slides and the links. Let me put everyone back on the slide with the links, so maybe you can jot down the employer's lawyers blog address here so you can see these articles. And I will see if we can send out the slides to everyone. I'm not sure, but if we can, we will. We'll send it out to everyone who signed up. So I think those are all the questions we have now. If you have more questions, feel free to write them in. If they come in a few minutes after we conclude, we can try and follow up with you. So thanks everyone for joining us. I hope this has been helpful. And I hope you can find your way through this strange new world that we're all trying to navigate through. Thanks, and have a good day. Bye.